This is part 2 of torts, beginning with defenses to intentional torts involving personal injury. We have consent. Consent can be either express and or implied. This can be by words and or actions which manifest a willingness to submit to the defendant's conduct. The defense of consent is not available for the mistake, where the defendant caused and or took advantage of the mistake. Fraud, where the consent was induced and or where consent was gained by duress. Consent and a lack of capacity. If you're young, drunk, stupid, this may undermine consent. Defense to intentional torts involving personal injury. Self-defense. You may use reasonable force to defend against offensive contact and or bodily harm that you reasonably believe is about to be intentionally inflicted. The force used must be proportionate to the anticipated harm. A reasonable mistake as to the potential for harm does not negate the defense. In regards to self-defense and deadly force, it may be used if you reasonably believe force against you is sufficient to cause serious bodily injury or death. Self-defense and the obligation to retreat. The majority rule is that you are not required to retreat. You may stand your ground and meet force with force. On the exam, please note that this is not the rule in Minnesota. You must first retreat before using deadly force in Minnesota. Self-defense and the initial aggressor is not entitled to claim self-defense. This makes sense. Don't know why I wrote that down. Self-defense and third-party injuries. The defendant is not liable to third parties and or bystanders injured while acting in self-defense. However, those injuries must be accidental, and the defendant must not have been negligent with respect to the bystander. Defense of others. Now, the defendant may use reasonable force in defending others upon a reasonable belief. The defended party would be entitled to use self-defense. Defense of property. Reasonable force is allowed to prevent tortious harm to property. Deadly force is not allowed. It's just property. Defense of property, specifically to intrusion. Reasonable force is allowed, but only after a request that the trespasser desist and the trespasser ignores your request. You may not use force or prevent intrusion, however, in an instance of necessity. Defense of property and recapture of chattels. Reasonable force is allowed in an act to reclaim wrongfully taken personal property. This does not apply where the possessor merely retains chattel past the time the owner consented to. So you can't expect something back from your buddy on Friday and on Saturday morning go over and beat them up and get it back. Parental discipline. You may use reasonable force and or confinement that's allowed as necessary to discipline. You must take into account the age of the child and the gravity of the behavior. An educator has the same privilege. You have the privilege of arrest, and this is for felonies, and we look at a private citizen and a police officer. Looking at a private citizen may use force. The felony must have been committed, and the arresting party has reasonable grounds to suspect the person they're arresting of committing that felony. There is tort liability for mistake as to the commission of the felony. Again, a felony must have been committed for a private citizen to use force and arrest somebody. For a police officer, they may use force. They may arrest somebody where they reasonably believe a felony has been committed and the person arrested of committing it. There's no tort liability for mistake as to the commission of the felony, as again, a police officer must only reasonably believe a felony was committed. Moving on to harms to personal property and land. We have trespass to chattels. This is an act by the defendant that interferes with the plaintiff's right of possession in the chattel. You have intent, causation, damages. The act is dispossessing or using or interfering with the chattel. This requires actual harm to the chattel or deprivation of use for a substantial time. The defendant need only intend to commit the interfering act. Transfer intent applies in trespass to chattels. Appropriate plaintiff is anyone with possession or immediate right to possess the chattel. Mistake by the defendant as to legality of their actions is no defense. Damages and remedy. There's for trespass and chattels is the damage caused and or loss of use. Where there is only use and or interference, the plaintiff may only recover where there are actual damages. Remedy, the plaintiff may be entitled to compensation for diminution in value or cost of repair. Some redundancy there. Looking at conversion, conversion is an act by the defendant that interferes with the plaintiff's right of possession of the chattel, which is so serious that the defendant must pay for the chattel's full value. Again, you have intent, causation, damages. Intent is the same as for trespass. It's only intend to commit the interfering act. Mistake is no defense. The interference is where the defendant exercises dominion and control over the chattel, such as wrongful acquisition, transfer, or detention, substantially changing, severely damaging or destroying, misusing. Now, in conversion, if the initial acquisition by the defendant is not wrongful, the plaintiff must first demand a return. Again, if you expect something back from your buddy on Friday, you don't get it back on Saturday. You have to demand return first before going over and kicking their butt. Looking at damages in conversion, damages is the full value of the property at the time of conversion, not at present time. Plaintiff may also bring in an action in replevin to recover the property, and that concludes part 2 of torts.